Hello, everybody. Welcome. Thanks for joining us today. My name is Mike Gibb. I run accountsrecovery.net, and I want to welcome you to today's webinar on Can I Use My Current Company Name When Leaving a Limited Content Message? The limited content message in Regulation F offers collectors an interesting opportunity to try and get in touch with consumers, but there are rules that have to be followed, notably whether the name of your company reveals that you are a collector. Today in this webinar, which is being sponsored by TCN, we have a panel of legal and compliance experts here to discuss the limited content message and answer questions about which words and phrases are likely to be considered those that reveal the true nature of a call. Before introducing the panel, I want to give my usual spiel about the accountsrecovery.net Slack channel. I did just put a link in the chat window to click on to join the Slack channel if you haven't done so already. Completely free, doesn't cost you anything. And by joining, you get to interact with about 615 or so of your closest friends and industry colleagues. I encourage everybody to do it today. It's a great way to stay in touch with one another. Now, let me introduce you to today's panel. Karen Enlow leads Smith Degnum's Consumer Financial Services Litigation and Compliance Group. She currently serves as chair of the Debt Collection Practices and Bankruptcy Subcommittee of the American Bar Association's Consumer Financial Services Committee and is co-chair of the National Creditors Bar Association's Bankruptcy Section. She additionally is the North Carolina State Chair for ACA International's Member Attorney Program and a member of the Bank Council Committee of the North Carolina Bankers Association. Most recently, she was elected to the governing committee for the Conference on Consumer Finance Law. Bill Marone is managing partner of the Connecticut creditors' rights firm Tobin and Marone. With more than 2 decades of experience in creditors' rights in the ARM industry, Bill represents credit unions, direct creditors, asset purchasers, medical providers, and collection agencies in all areas of creditors' rights law. He is currently president of the Connecticut Creditors Bar Association, is the current ACA International State Attorney Chair for Connecticut, is Connecticut Legislative Subcommittee Chair for the Receivables Management Association International, and he has served as Subcommittee Chair of Technology and Information for the American Bar Association's Credit Union Committee. He's also a member of the NCBA Defense Bar and serves on committees for both NCBA and RMAI. Rick Purr is the co-managing partner of the Philadelphia office of the law firm Kaufman, Dolowitz, and Volokh. He also chairs the firm's National Consumer Financial Services Practice Group. He is nationally recognized authority and lecturer on creditors' rights, representing creditors, law firms, and agencies against individual and class action allegations invoking federal and state consumer protection laws, including the FDCPA, FCRA, and TCPA. Rick is a past president of ACA International and also sits on its board of directors. The format for today's webinar is going to be a mix of a panel discussion and Q&A session. We encourage everybody to submit questions, and we'll get to them during the course of our discussion today. If you submit a question, please either enter it into the Q&A tab on your Zoom webinar control panel or send it to us through the chat window. Since our panel is going to be talking about compliance today, let me read the following disclaimer. This presentation is not intended to be legal advice and may not be used as legal advice. Legal advice must be tailored to specific circumstances of each case. Every effort has been made to ensure this information is up to date. It is not intended to be a full and exhaustive explanation of the law in any area. It should never be used to replace the advice of your own legal counsel. All right, while we wait for what I'm hoping is a slew of questions to come in from our audience today, let's talk a little bit about the limited content message. Maybe we can start by explaining what it is and what are the benefits to using it. And Rick, we'll start with you.
Great. Thank you, Mike. And I appreciate the opportunity to present today with great panels like Karen and Bill. It's always a pleasure to be here. The limited content message, which came out of the Reg F, and for anyone following along at home, if you'll recall that the rule was released in 2 parts, one in October and one in December. This would be in the first part, and that was released in October. And for all intents and purposes, it said, and created a new message that did not constitute a communication for purposes of FDCPA liability if you utilized it. We'll talk a little later about how it plays as a role with the call caps and its use in that regard. But what it said was you can effectively, it's like sort of a hybrid of what was used to be said with Zortman, with a little bit more information and some permissible information, but that you could call and leave a message. And if you left this exact message, then you would have a degree of a safe harbor from actually having made a communication, and thus some protection from lawsuits in which a third-party disclosure would be the issue. If everybody remembers back to that whole dichotomy between Foti and Zortman and whether or not you should leave a message or shouldn't leave a message. Well, in summary, the CFPB has said, here you go. Here's a very limited content message to give you the opportunity to leave it. It's not going to create liability for you if you leave exactly what we say. And their belief is that it would prevent repetitive phone calls because you are going to leave the message. You are going to wait a sufficient number of days, hopefully to have the consumer call you back. And then you'll be able to engage in a conversation with the right party contact. As opposed to calling, not getting an answer, not leaving a message because you choose not to potentially violate a Foti type of third-party disclosure issue, and then immediately calling back the next day because nobody called you. That's at least the rationale. And I think of all the things in the new rule, this is one of the more welcome aspects, at least for the industry.
All right, thanks for that. Karen, Bill, anything you want to add on top of sort of what the limited content message is and what some of the benefits are before we move on?
Sure. So it's as much about what it is as what it isn't. It isn't a communication as defined by the definitions. And it is an attempt to communicate. So that's where the safe harbor is coming from. Whereas in the past, there was sort of a gray area. I think that's a big piece of what it is. One of the things it is, though, is an attempt to communicate with the consumer. And the CFPB went very far. Make sure as you're reading your rule, you're ferreting out what was proposed and what is final. Because proposed included text and oral. Final is voicemail message only, right? So they limited it just to create and sort of resolve what they saw to be a potential harm from the Foti-Zortman split. And I live in the Foti circuit, and I know a consumer attorney, if any are on the call right now, would never believe this, but I think that the harm created by the Foti message far outweighs the harm it was attempting to prevent. So as a firm in that circuit, I welcome the limited content message. I find it to be a much more consumer-friendly version of the message that I live with now. Karen, did you have anything?
No, I mean, I agree with everything you said. And I think it is really important to consider what the changes that were from the proposed rule to the final rule, and that this is limited to voicemail messages only. Whereas in the proposed rule, it was more extensive. I think it's like any gift that the CFPB gives, it comes with some conditions attached to it that take away the bow that could have been on top of it. Particularly as to the business name, which I know we're getting ready to get into.
Do you guys think that as the fact that it resides in the definition section, and especially the sort of makeup of the judiciary at a lot of levels as strict construction, you know, we used to fly right past definitions. The limited content message is in there. Do you think that will have an impact on how the judiciary looks at it? I mean, are they going to parse word by word and you know, as Manny would say with the validation notice, don't mess with the limited content message?
Well, I think that's definitely going to be Manny's new mantra, but I think the fact that's in the definitional section may give our friend Rick a little help. Because the one thing that occurred to me is that it's pretty much just the opposite of the definition of a communication.
Right.
Well, they created this new category, an attempt to communicate, which they then try to parse out from things like the 7 and 7 rule for your call caps, where they say that includes attempts to communicate as well as actual communications. You know, you have your attempts to communicate, which fall in that section under the 7 and 7, and then you have if you actually communicate, now all of a sudden you're in the sphere of you got to wait 7 days unless you have consent. And I think, they're creating a much more complicated definitional scheme, no doubt about it, but trying to design a way to give some safe harbor. And I think, we won't know until the litigation starts flying, which inevitably
will.
we know it will, from our friends on the plaintiff side. But I think it does give a lot of license to district judges to grant motions to dismiss, right? By putting it in there, by putting things in there, and just taking a look at the actual content of the message, which we'll get to shortly, you're going to see that, look, they left a message. Maybe, they're going to have to allege in a complaint, we got communicated with or we left a message. I'd make the argument that by making that allegation, it draws the message into the complaint, which then the defendant debt collector can use, since it is referenced in the complaint, as an exhibit, whether through the actual audio hearing or a transcript and the audio hearing, so that the court's going to be able to look at the exact language that's used for that message, even on a motion to dismiss, and be able to hear it, apply right to the definition, look right to the rule, and say, yep, it's a limited content message. There was, and it only constituted an attempt to communicate. It wasn't a communication, no FDCPA violation.
Well, and that brings up
That's
a good
my
point
fingers crossed.
that, it's in the, if you go to the official comments, there's little gems dropped all over the place that at a minimum provide, I think, a bona fide error defense, and going even farther, perhaps a safe harbor. And the limited content message is one of those. There is specific language provided in the official comments as to what's an appropriate message. And so that comes right back to what Bill was saying. I'm sure Manny's going to say, just use the damn message that's in the comments and you should be okay, assuming you can get past the whole name issue.
Right. And I think we should also note, just for everyone that's listening, which is, I know there's a couple questions that have been thrown up, is you don't have to use the limited content message. You can still do what you're doing and still deal with everything that you were dealing with. Just understand that you're still subject to potential third-party disclosure, or if you're using the Zortman message and you think that suffices and the ruling that was done in that case, that applies to your situation, you can still, give yourself, you can still use that message. I think really what the limited content message is designed to do is to provide a vehicle for those agencies that chose previously not to leave messages, to give them at least a little nudge to say, okay, you don't want to go full board message, we'll give you this limited content message. Hopefully you'll use it and you'll get to a situation in which the calls to consumers will decrease because you're leaving messages and not feeling the immediate need to make another telephone call because you didn't reach somebody.
That's right. It's giving you cover.
Yeah.
So in that way, are you saying it's ultimately I guess it always is, but it's ultimately sort of more of a business decision whether or not you want to choose to leave the limited content message and go through everything that you may need to go through, versus either not continuing to not leave messages or using one of the existing voicemail messages that's kind of been signed off on by the courts?
That's right. I mean, it's a business decision. I think you have to look at how many callbacks you're going to get from that message, because it is so limited in its content, no pun intended, is how much bang are you going to get for your buck? And is it worth all the things you're going to have to do it? Or has everyone adapted to the point where they're comfortable? What it does is it gives you a little bit of cover that if you do it the way they say do it, and you can fit within the four corners of the rule, that you've got some protection from a violation. That's really all it does. Can you leave another message? Sure. You're not going to have any cover from it. You're running a risk. It's a calculated risk and it's a business decision. But I'm not sure how when I saw it, I didn't, Bill was saying earlier, he looked at, this is exciting. I looked at it and said, I'm not sure this does much for you because it's so limited as to what it says. But I will tell you that basically to make feel better, the consumer bar is up in arms about it. They don't like it. I was on a panel with a consumer advocate about a month ago, and they are hot, and they're hot for reasons that we wouldn't think of, which are abused spousal issues is what they think it will tie to for abusive spouses to use it as leverage. So it's really interesting. Their take on it has nothing to do necessarily with debt collection.
Carol, Karen, is it because they, the name of the consumer is not indicated in the message, so they feel like it's a household harm?
Yeah, and it's crazy because the only thing that makes me happy is that they're unhappy, right?
Right.
So if they're unhappy, then I'm necessarily happy. But yeah, it was weird, Bill. It was not what I expected them to be upset about, but it's the fact that it doesn't identify in between a spouse. You're one of two. You can figure out who it's for, and they're really concerned about the use of it, which I not for the reasons we thought.
And I think that, we're about to jump into it, but the message is not for everyone even from a technical standpoint. The CFPB recognized, and I think that there's a lot of deviation here on the limited content message from where they are on the model validation notice in the letter format, which they say you can use their model validation letter or a substantially similar product and still receive some of those same protections. Here they say, you must do exactly as we say, no deviation at all. If you have to add something because there's a state disclosure requirement you have on an oral communication, you don't get the limited content message protection. If the subject matter of our conversation today, which is the name, if your name doesn't meet that criteria, you can't leave the message. So you may have the decision chosen for you simply by virtue of who you are or what state you're in.
Yeah, like I said, this to me is not, this is really of limited value. I didn't get real excited about this provision in the rule ever.
I'm just going to interrupt for a second. I want to hit the pause button briefly on our discussion and say a few words about TCN, the sponsor of today's webinar. TCN is a global provider of comprehensive cloud-based call center platforms for enterprises, contact centers, BPOs, and collection agencies. Last week, it announced the launch of TCN Operator, the next generation of its flagship platform. Built for the modern call center, TCN Operator features an intuitive interface and a comprehensive set of easy-to-use automated agent tools and advanced apps that all work together to boost agent productivity and improve customer experience. TCN Operator's features include omnichannel communications via voice, text messaging, and email that provide a seamless, unified experience for call center agents to interact with customers, business intelligence reporting and analytics that provide a 360-degree view of call center operations to identify anomalies or trends and generate actionable insights, data management and compliance tools that ensure adherence to the TCPA, FDCPA, and other state and federal regulations, including new and updated debt collection rules issued by the CFPB, workforce engagement to manage all aspects of call center operations, including scheduling, forecasting, onboarding and training, evaluating performance for productivity, resolving conflicts, and documenting compliance, and seamless integration and automation with third-party services and applications, automating key tasks, including dialing, predictive dialing, IVR for routing calls, and interactive voice messaging. Grounded in TCN's deep understanding of call center needs, TCN Operator is built on the company's vast experience in supporting billions of interactions every year between call center agents and customers. For more information about TCN Operator, you can use the link that I just put in the chat window to find out more. Thanks again to TCN for sponsoring today's webinar. All right, we've got a few questions that have come in. So I'm going to take a second and we'll get to those. The first question was for you specifically, Bill. Can first-party collectors continue to use creditors' names in the limited content message? And maybe we can just use that as an opportunity to sort of expand on what has to go in the limited content message before we start taking more questions about whether or not certain things are okay.
Sure. So the limited content message has 4 required and then a handful of optional disclosures that can be included. And like Rick said, There is no substantially similar version to this message. You have to have these 4 things at a minimum to be compliant, and then possibly some of the optional versions. So from the required content, the whole point of today's call in webinar is the business name, which does not indicate that you're in the debt collection business. So right away, I did a quick scrub of the ACA member directory. 260 hits from the word collect, 183 with recovery, 18 with debt, 64 with account. So the 3 of us on this call will be very busy figuring out which of those words indicate if you are in the debt collection business. So that's 1. You can leave a request for the consumer, or you must, not you can, you must leave a request for a reply from the consumer. This call has to be directed at the consumer. You cannot be making a location information call or a similar third-party call and get the protection of the limited content message. So step 2 is a reply from the consumer. Step 3 is you have to name of an individual, a natural person, or persons with your firm or business that the call can be directed to. And then the last piece of required information is the call number. So you have to hit 4 for 4, not 3 for 4, not 2 for 4, 4 for 4 to get the protection of the limited content message. And then they're so generous, you can, as an optional piece, say hi, potentially hello. I wouldn't do hola or здравствуйте because you may be walking in second language, but you can leave a salutation. You can also leave the date and time that you call. You can let them know that they can speak to any of your representatives. So you can speak to Jane Doe or any of the representatives with our firm. And you can leave the preferred callback hours. So those are just straight from the definitions. And so you need to do that. Now, to address the question of, does a first party creditor have the ability of in the safe harbor, the limited content message? Remember where this rule is directed. I had a meeting with Corey Stone, who was one of the CFPB people who helped put together the rulemaking team. And it was about a month ago. And I asked him, I said, what do you think? And he said, it's only halfway done because it doesn't touch first party. And so that shook me a little bit. But in response to the question is, this is third party debt collection rule. So, and Karen and Rick can tell you, just because it only governs in one space doesn't mean consumer attorneys will not extrapolate under first party state rules. I think the great attorney Purr on this call may know of a state law that sort of mirrors FDCPA in a matter he may be involved with. So you can get sucked in. So limited content message isn't currently for you, but it potentially could be guardrails for best practice. So I don't know what you guys, hopefully that was responsive.
Oh, I think that was great, Bill. And I think it bears emphasizing the CFPB was explicitly clear. This is a rule governed to debt collectors as they are defined under the FDCPA. However, they also regulate other consumer financial service providers. They have guidance as to UDAP claims, and they say very clearly that they're not, this rule does not govern them, but they leave the door open that these practices would likely constitute UDAP practices, which could lead to regulatory enforcement actions, not under the FDCPA, but under Dodd-Frank.
I think also to keep in mind is the strict requirement of the limited content message. You can provide your name. It doesn't provide for anything other than your name. So if you're making a call and you want to get the protections of the limited content message, you have to leave your name. To say your name, I'm calling on behalf of a creditor. I think you're really running into an area that most judges will find that doesn't fall within the context of your name. to add superfluous information. Look, for the optional section, as Bill pointed out, they're putting things in like a salutation, and both at the beginning and end. I mean, they literally have to go to the point of telling you, you can add hi, hello, goodbye to your message. If you're going to an extent to have to add those type of words, then clearly if they intended for you to add the name of your creditor client, they would have identified that. And even the commentary specifically indicates that they expressly excluded the word account out of this protections. And originally, if everyone remembers back during the course of the 17,000 years that it took for the CFPB to promulgate the rule, at one point they offered some model commentary and had suggested that a message or message of this sort could use like words like account or other information. They go to make sure that they're clear in the commentary to say, we expressly said you can't use account, because to us, the use of the word account suggests debt collection and takes it out of the sphere of a limited content message. So if you were going to say, we're calling on behalf of a particular creditor, I think that would be even more injurious and invoke some of the same protections that they were trying to avoid. So I wouldn't do it at all.
Yeah, and look, this is from a compliance perspective. For the compliance officer, this might be the easiest piece of it. If you go to the official comments, and I'll even give you the page number on the CFPB's version, you get page 598 through 599. They give you an example of what the message must say. This is Robin Smith calling from ABC Inc. Please contact me or Jim Johnson at 1-800-555-1212. And then for optional content, they give you another message you can use. And so I think, you've got to stick to the script. And if there's nothing else people take away from this as far as what the contents of the message are, it's stick to the script.
We had a question that came in asking about the phone number. If the phone number identifies somebody, can that, would a local area code number be considered in violation of the new regulation F?
I don't think the area code would be. I think a vanity number. And I think, if I remember correctly, they addressed that specifically in the comments, not the rule itself, but in the comments. But I think just using a local number in of itself, the rule's silent on that. I think if you get into it's 1-800, we collect debts, that's where you're going to have an issue. I don't know. Did you guys see anything that I missed on that in the rule?
No, I didn't see anything in the rule, and the CFPB and other courts have addressed the issue of local calling numbers, which is under more or less under the misleading and deceptive conduct. If you call the number back and you get the collection agency, you're good. That's really to sum it up in a nutshell. If the number that you're leaving is not yours, or it doesn't get back to you, and the person who returns the call can't get to you, you can't use that number because it's considered deceptive and misleading through other aspects of it. So I don't see any reason why you couldn't. And there's plenty of vendor services out there that use local caller ID as a product. And as long as you're using those products right, you should be okay.
While we're on the topic of phone numbers, what about caller ID, the name that sometimes shows up with a phone number? Does that have to be changed if you're using a DBA? If that has collection in it or anything else that may identify, do you have to change that? The caller ID name as well?
I don't know about you guys, but I think that if you are gonna avail yourself and use the limited content message, it is one of the largest business decisions that you're going to make. And in all likelihood, if you are one of those 64 members that have account in your name, because as Rick said in the commentary, account isn't in the message because it connotes debt collection potentially, that may be a word that shouldn't be in your name. So if you're in a position where you were either already considering rebranding, just because you feel like it's good business in the current climate to rebrand and take out some names that might connote debt collection, then I would continue those discussions within your firm. If you're not, you need to think of all of your channels. It can't be, the limited content message is a monorail, not like the 2-track path with substantial compliance in between of the model notice. This is a monorail. And so if your caller ID gives a disclosure that would be problematic, or you leave your assumed name, but then your firm, when you call that number back, says, hey, we're debt collector 123, you could be walking yourself into problems. So this is not just we're going to leave a name that we registered with our state on our messages, but everything else is going to be, collect big bucks, Inc. I think you need to be mindful of all those pieces.
I don't know what you guys, but I have clients tell me that they don't get to control what the caller ID says. That's the telephone company. So I think what Bill says really should resonate with folks is that you're making a rebranding decision. And that means that if you can't just change it on one channel, you're going to have to go to your telephone provider, change the name on the account and everything else to at least do the best you can to ensure that that's not coming up with something that arguably, I don't think the rule covers it, but I think that arguably is going to be an increased risk of litigation.
The alpha pulse usually is designated by the carriers unless you have previously specifically identified something. So you can be in a situation, and there are situations where the alpha that comes out does not even relate to who's calling because some carrier or somebody has it connected to a previous phone number holder, which, with this universe of local calling where these numbers tend to get shopped and resold after a period of time, that's a possibility that exists. And I don't know what would happen if it pulsed out. Whether you'd have some sort of bona fide error defense that you had no control over it. It would be interesting to see. I wanted to move because I saw this question that sort of hit right on the exact topic that we were talking about, which was someone put into the chat box their company, and then I guess since they put it in the chat box, we can talk about it specifically, which they say their name is RR Resource Recovery. And they've concluded that using recovery is a no-no. We want to consider using just RR resource, but consider that it's deceiving if they just use that without the word recovery, and their current counsel punted. I'll say before I start to try and answer the question and ask our fellow panelists is, clearly any advice, even though the three of us are lawyers, is not your legal advice, but rather our opinions. And you need to consult with your own counsel for specific situations like this. But here's the focus of this webinar, which is what happens if you get one of those names that Bill has uncovered. Your first question that you're asking yourself is this word a no-no? Now, do I have to not use it? Clearly, debt collection is bad. Things like recovery, account we perceive to be bad, though there's nothing expressed that says the word account in there. Bureau, credit, some of these magic words that we're not 100% sure. And quite frankly, like Bill, I've had some discussions with some industry-wide CFPB people talking about this, and they have punted, basically saying they're giving no opinion as to what they mean and what is being limited by the limited content message name designation. So your first decision is this a no-no? Do I have to change my name? Do I have to do something? Even something as simple as abbreviating your name. In almost all cases, and I know that the writer disagrees about whether it can be deceiving or not, the fact is that if you are using a name that's not on your license, if you are using a name that is not registered with your Secretary of State or in any foreign jurisdiction in which you are doing business, and you haven't registered anything other than the legal name, for purposes of the FDCPA, that's not your true name. And I would be very cautious about suddenly changing anything if you have not registered it first. And that may take two aspects. Like I said, you may have to go to your Secretary of State or your Corporations Bureau where you are currently registered to do business and fill out a DBA or something similar. And by doing so, that may invoke the necessity to have to do that on your licensing in various states. If you're going to change your name or use an abbreviation, some states require you that all DBAs have to be registered on your license. So again, this is the big limitation of the limited content message. You may have to change your name. And if you do, you got to take a lot of steps potentially and work with your compliance and your counsel to figure out what you have to do to be in compliance. It may be a bigger hassle than it's worth to go through some of these hoops in name changes. And so, you know, it is a difficult path to follow. Now, see if Bill or Karen has anything to throw in on that.
It's not just in one state. Yeah, it's not just one state. It's in every state in which you do business, which may not be consistent with each other. You may have some states where you can do a single location state registration of an assumed name, and some that require county by county. And so you really have to think all of that through, make sure that everything's right on your license. Then you're also going to have to change all of your letters to with your letter vendor or someone else to make sure that those are consistent. You have to change all your scripts. I mean, you're not going to be able to use one name for your limited content message and another name for everything else. And so there's a whole lot. It's not a simple decision to make. It is, as Bill said, a rebranding. And there's goodwill that goes with your name too. You have to think that through, and your contracts, all of it.
I was thinking about it as we were getting ready for today, and I was thinking maybe this would be a relatively low risk area for either industry association or even an individual firm, because you don't have to use the limited content message to avail themselves of the advisory opinion process. If you have one of these words, right, that is not per se, it's not debt, it's not whatever, ask them. And if they say no, I haven't started using the message yet, so I don't have any exposure. And potentially I will know and have some of the cover because I'm operating under an issued advisory opinion. So that was one of the things I thought about. I was talking with my compliance officer before we started today, and he said, this will be the one area of law where the least sophisticated consumer is very sophisticated. They will know acceptance means debt collection. They will know account and recovery mean debt collection. So he said it'll be interesting because they will wear a very sophisticated hat with the words that they try to parse out as to knowing for a fact that this was debt collection. Everywhere else in the
at least the lawyers will be
find out which of
sophisticated.
these words work and which don't either, because I think some of them are, you know, kind of obvious, and others, I don't know that they are. We've got law firms that have very recognizable names in the area of debt collection. By virtue of using their own name, doesn't that do the same thing?
We have someone else who suggested put out the word revenue and wondered whether or not that would be okay.
I mean, I think that again, we're in gray areas because the CFPB on stuff where there were a lot of things they just kind of punted on and said, you know, you guys can leave that to the courts and yourselves to figure out. But revenue would be one that I could see going either. I can make an argument either way. And
Does
if I
the
can make an
context
argument
matter?
either way, then there's an increased likelihood of litigation.
Does the context matter? Like whatever the sum total of the company name is too, you know, like
Yeah.
versus sort of any one word. Like if I could come up with an acronym, and I've been trying, I can't come up with one that spells DEBT. Can you use, can I say all of those words, but people are going to know when they put it together, it spells debt, you know, like how do you is that another thing to kind of take into consideration?
I mean, I think they're going to look at, I think that you have to look at the name as a whole, but there are certain words that are going to red flag. You know, accounts recovery. what, you know,
I'm not
right
calling
there, I'm
anybody.
just staring at your background, Mike, and it just kind of, you know, right there. I might think that you're a debt collector. You know,
I'm not leaving any limited
I
content
think it's, you
messages.
gotta have to look at all of it together. But there are gonna be words that are red flags, and there's gonna be a lot of words that we're gonna be fighting over for the next several years.
It's good for me because my kids are not scholarship kids and college is around the corner. So I'm happy to represent anybody who wants to test the waters.
You know who your potential clients are. You've done the research on it.
He's already started marketing to them. That's why you got the list.
Nice work there, buddy.
That's proactive. Does the pendulum swing the other way too? Like if I, like, let's say I've got, you know, I put this to the panelists, and my name is National Collection Agency, and I turn it into an acronym, NCA or something. Does the pendulum swing the other way too? And that, you know, you have no idea, you know, like, you know, can a consumer claim to be, you know, that he or she is being misled or deceived because the name was so innocuous?
So if you register the name, then they're under, by every law, you're under constructive notice. If you've done all the
Okay.
steps and register, you can't say I'm deceived. It's constructive notice, and every court will take, you know, just like you can't drive down a road and say, oh, I thought the speed limit was 50 and it really was 25. You're on constructive notice of what the law says. You're on constructive notice of what's registered in corporation bureaus as a resident or a person in that state. Those things are deemed to be public records, and you're deemed to have to know them or understand them or can't sue on them. Let's put it that way. Look, and from the agency's perspective, their answer is pretty simple, which is if I can get somebody to call in for whatever reason, even if it's, I don't even know who you are, why are you calling me? Once they picked up the phone and called in, that's a win for the collection agency, because now you can have a conversation with them, verify that it is John Doe, verify that they do owe the debt, or that they understand that they possibly can owe the debt, and then what payment plans can you work out? What arrangements can we make? Or alternatively, we have the exact absolute wrong number and the wrong person, and we need to take that out of the system. So any reason to get somebody to call in is a win for the collection agency, because for a number of reasons. Not just do you get to potentially resolve an account or figure out something, but you also have that right party contact. And that means fewer outbound calls to that number, which could result in calls that are either deemed too frequent, harassing, disturbing, annoying, that would lead to lawsuits. And that's really what we're trying to accomplish, is just trying to put two people together and figure out where it goes from there. And the fewer calls, and I think this is what the CFPB understood, and they say it expressly, it's not just what they understood, the fewer calls between agencies and consumers, the better. Other modes of communication are not as disturbing. Emails, texts, ringless voicemails, all of those things, they make a clear demarcation in their commentary that they deem those to be less intrusive than the ringing of a telephone. And these rules are tailored to that extent.
Yeah, I think it's important to remember we're talking about the option to leave a message. And so, you know, and calling and leaving a message are not necessarily one and the same.
So hi, this is Mike from youwontheLottery.com. Probably not a good idea. I think you mentioned,
what you're going to call your new collection agency?
another question, I think we talked about this one, but just a question asking if the word adjustment would potentially raise red flags.
I mean, yeah, it does for me, but I'm doing it in the context of not just the word adjustment. Or the name of the company is chiropractic adjustment. That doesn't bother me. But if it's revenue adjustment or something like that, that bothers me.
And I agree with Karen in that regard, but I have less concern with the word adjustment than I do with recovery.
Yeah.
So it's
on a scale. Maybe we
Yeah.
should create a scale, the scale of collection. And we put all the words, you know, there's words that are safe. There's words that are like, whoa, don't use that word debt. That's a bad one. So they're red words, yellow words, and green words. And you put them together however you want. But the more green words you have, the better off you are. Maybe that's what we need. Do you think we can, hey, Bill, do you think we could like market that?
I think that's it's going to be like a Price is Right game. We'll just have it.
That's right. I feel like we could come up with a cool name for the scale too.
Or right, it would be something similar to the Bush era terrorism threat level. We had all of those colors.
Right,
Exactly.
exactly. Yeah, so I mean, I think that's all of that. But I'm seeing all these names thrown out now in the comments. Risk analysis.
Yeah, and I
This
think
is where that least sophisticated consumer gets very sophisticated, you know, because we
That's
sit
right.
here with a unique industry knowledge of some of these terms, and it's tough to divorce ourselves of that. But the consumer bar has that same info. So if I were to turn my hat inside out and try to protect the client by drafting a consumer complaint and saying, this is how I would attack you, I would just say, hey, listen, the juice may not be worth the squeeze on the limited content message. It's
That's
only
right.
one new arrow in your quiver, not necessarily taking away other existing ones. That could change, but that's how we sit today.
Well, and I think the problem, and I think you're right. I like I said, I never got really excited over this or saw it as like the be all and end all. I appreciate they were trying. I think the big thing, the big takeaway for me with it was, here is the CFPB trying to minimize litigation over an area that clearly has been heavily litigated for 15 years. Whenever FODA came out, I don't even remember. I remember when, but I don't remember the year anymore.
06. It still makes
Yeah,
me
I
shake.
remember we all sat in
lived-
San Diego at ACA trying to figure out a really good message that we could do because it was right there and it was in San Diego. But I feel like we kind of got past that litigation for the most part over the last several years and kind of figured it out ourselves. I think the big takeaway is here's the CFPB trying to come up with a practical solution. Whether it is one or not, you know, I don't think, I think it's going to be hard by taking out a name, having in the name something that does not indicate you're in the debt collection business. Well, there's some debt collectors that are nationally known and they have none of those words in their name, and everybody knows they're a debt collector. So just the fact that they call is enough to do that. So I'm not sure that this does what it's supposed to do.
So what would your solution be in that situation?
I mean, technically they're within the rule. I mean, they're not using any words that indicate they're in the debt collection business. They just happen to be famous. Like I said, I think this provision, I think, has limited utility. It's like the debt validation. As people that want to use it to collect the debt are not getting the point. All you're trying to do, this limited content message, is like Rick said, is you're trying to get a callback. And how many callbacks are you going to get on it in the first place? How many people really want to call you back?
I think that you have if you have agencies today that are leaving messages as a business practice already, depending on how many lawsuits they're getting for third-party disclosure, or if they're getting any at all, will impact whether they even want to switch over to this message. And for those agencies that are not leaving messages for practical reasons, that they don't even want to deal with it, this may just be the entry level where they figure, okay, so on some accounts, we'll give it a shot, we'll give it a try if we qualify and see what happens. But right now, they're not leaving messages anyway. So what do they have to lose as long as they can be compliant with it? And that's all. That's really what's going to happen. There's no obligation. It's not the model validation notice, which seems to suggest that's the one you have to send. The limited content message is you don't have to use it. You just don't. And it just becomes a tool for who wants to use it and provides a little bit of a safe harbor. But the people out there that are using their messages are probably unlikely to change their whole operations to try and conform around this very limited content message when they can currently just, if you think about it, if you leave a Zortman message, you can now say, I'm Debt Collector Inc. We are a collection agency. The purpose of this call is to collect the debt. Please return our call at this telephone number. And as long as you don't leave the name, arguably under Zortman, you haven't done third-party disclosure, and that message should hold up. You may have some issues on inbound and who calls in and how you route that call, but you can leave that message and it sort of tells everything you need to know. You don't have to change your name. You don't have to do anything. You have a methodology, and if you're comfortable doing that, then you're probably the limited content message is not for you. But if you're getting sued 50 times a year by doing something similar to that, then all of a sudden it may become a practical business way to at least leave your initial message to try and get a return call.
We've talked about this being a business decision. How would you advise a company make the decision? They can't really test the limited content message yet, unless they would have to go through the process of changing their name or doing the DBA to use it. So how would you advise them to sort of make that decision and go through the process that they need to go through to determine whether it's worth the effort or not? Because you're not really sure what the number of calls is going to be that you're going to get back if you start leaving a limited content message.
I think Rick just really kind of walked through that pretty well, Mike. I mean, I think it comes down to, what's your risk? What's your appetite for risk? How many callbacks do you get from messages you leave, if any, already? So is there a business basis for leaving messages? There used to be. What jurisdiction you're in? Is it one that's accepted Zortman? What's the cost going to be involved to switching everything over? And you're going to have to weigh that cost against the benefit. And I think it's a cost benefit analysis once you walk through all those issues. Is there going to be enough bang for your buck to justify leaving limited content messages, understanding all of the changes in the potential rebranding you may have to do?
Or at least co-branding. I don't know that you need to do rebranding in its entirety. If you're doing DBAs and you're doing things, you can continue to use both names. You're just
I think in some states you can, but in other states you have to operate in your true name. And so if you have to say, you have to put out that true name, and unless you're going to make your old name your DBA. I mean, I think that's when you got to think out, and I think you have to look at it in every state.
You definitely have to do that.
And the piece of the fair debt has not changed about operating in your own name, so it's got to be one of them. It can't just be we wake up tomorrow and we'll call ourselves this and see what it looks like. It can't be a fictitious name, or you're already going to run afoul of, I think it's 1006.18, where it would be deceptive. So, you need to, if you haven't started thinking about it and you think it's for you, need to start now, because it's not we'll wake up on November 30th or 60 days after and say, okay, let's roll. It's not going to work that way.
Yeah, and you're going to have to go through with all your licensing boards too, right? Get all your collection agency permit names changed over. I know a lot of them do that in July. Other ones of them do it the first of the year. So you're looking at having to go through an additional layer with them potentially, where you're submitting stuff. They were going to want to see, a lot of times they're going to want to see your entire letter pool again and go through that. And so there's a lot of pieces to it beyond the obvious. Just we're going to change the Secretary of State and we're going to get our certificates of assumed name. I think you have to look at it from the licensing perspective too, and what your state regulators are going to require, in addition to just saying, hey, we're changing our name to this. What are you going to have to give them? If you want to do that twice, if you're having to change all your letters anyway because of, certain validation notice.
The Christmas present we unwrapped on October 30th, it's not a lump of coal, but it's an apple. It's not, it's okay.
I wouldn't even give it apple quality.
I'll take it.
Well, that was going to be my question. Is we've talked about, the expected litigation that you expect to see because of this. You talked about everything that's going to go into it. I'm curious, do the three of you think that you're going to see a lot of companies avail themselves of this, or choose not to because of all the hoops that have to get jumped through?
Well, I think there's two classes in there, Mike. There's the class that's going to leap before they look and just go ahead and say, we're going to use this. This is cool. And they're not going to go through all the formalities they have to. And then there's going to be the companies that really kind of run through the cost benefit analysis. My guess is the ones that are doing the cost benefit analysis, maybe 50-50, but I'm not even sure it's going to be that high.
So that first group is the one that's going to put Bill's kids through college, though.
That's right. Those are the ones Bill wants as clients.
You can call me at 1-800-DEFEND-DEBT.
And you're going to see, it's going to be for some people, it's not going to be for others. And that's really just like a number of these things in the rules. I mean, if you look at things similar to the electronic communications, whether to use emails, whether to use texting, whether to use any of this stuff, there's just going to be some agencies that they're going to see a benefit of it and others that are not. And the limited content message is not for everybody. It clearly eliminates half the people out there because if they have a no word in there. So, in all likelihood, many clients are not going to want to go jump through the hoops of changing their name or doing that stuff for a limited content message. Is there going to be litigation over it? Of course there is. There's nothing in this new rule that there isn't going to be litigation about, at least to test the edges for the first year or two. And as you see decisions come down and whether plaintiffs' attorneys find that there's marketability in testing the new rules or find that they're wasting time and money, will really be the deciding factor from their end, whether they want to bring these suits. But the CFPB itself notes in its commentary, some of these rules are not designed to eliminate litigation. They are designed to provide a pathway that hopefully the litigation gets resolved quickly and with uniformity. But they say, they're not doing things to stop litigation. And I think that that's an important understanding about this new rule. It has some industry-friendly components, but it is not there to necessarily protect the industry.
Yeah, I've told our group that there are 3 stages of rulemaking. The rule comes out and you submit comments. The rule gets finalized, you provide compliance advice. The rule gets enacted and you provide litigation services. And we're getting ready we're in phase 2 and we're getting ready to hit phase 3.
Is that also a red, yellow, green scenario too?
Oh man, that is green.
Elevated threat level.
Well, unfortunately, we've run out of time, so we'll have to wrap things up. But Bill, Rick, Karen, thank you so much for sharing your wisdom and your perspective on this important topic with the audience today. On behalf of everybody who I think is walking away a little bit, with a little bit better, a much better understanding of what they'll need to do and how they'll need to go about doing it with respect to the limited content message. Thank you very much. I really appreciate it. I want to thank TCN one last time for sponsoring today's webinar. Please check them out at www.tcn.com. Thanks to everybody who watched and listened. Your support is always appreciated and never taken for granted. We're back tomorrow with the May edition of Q&R. We've got Provana, Prodigal, and PDC Flow giving presentations and answering questions like Shark Tank from a panel of judges, including Tim Collins and John Keelan from Hunter Warfield and Dan Medina from Gulf Coast Collection. So if you haven't signed up for that, you can find a link in the events calendar on accountsrecovery.net. We hope to see you there. And then we're back on Friday talking about FCRA investigations. So you sign up for that webinar as well. Thank you very much, everybody. Really appreciate it. Rick, Karen, Bill, thank you so much. I really appreciate your time today.
Thank
Thanks
you
for
guys.
having us.
Bye.
Thank you,
You
Mike.
guys.